Good morning, Commissioner. Steve Rouse. I'm the president of Rogue Advocates. We are also an appellant in the LUBA appeal. In their brief discussion, Commissioner Heck offered up the question to make sure that approving this comp plan ordinance would not violate state law. Indeed, it does violate state law, and the LUBA decision that Mr. Corcoran cited is the precedent. It's a very well-established precedent, and it's probably so well-established that some have forgotten about it. The issue is jurisdiction. The question is, does the county have authority to move forward with actions on this application? The LUBA case, which was Standard Insurance versus Washington County, the specific question in that case was if the county retains jurisdiction to adopt a comp plan change amendment when the underlying decision is under appeal. It's the very issue we're talking about here. This decision established the precedent that counties have no jurisdiction to move forward with codifying comp plan amendments while under the jurisdiction of LUBA. And I'll read you a few excerpts from the LUBA decision that are to the point. LUBA discusses, let's read it. ORS Chapter 215 generally establishes county authority for planning and zoning. ORS 215.50 grants county governing bodies authority to adopt and revise comp plans and sets out procedural requirements for such actions. However, we find no provisions in ORS Chapter 215 which address a county's jurisdiction over a comp plan amendment decision or any other type of land use decision while that decision is on appeal to LUBA or the appellate courts. LUBA continues with the discussion of ORS Chapter 197, which is a couple pages. I won't read you that. But their conclusion is, we find there's a clear pattern to these statutory provisions for appellate review. Where jurisdiction is conferred upon an appellate review body such as LUBA, once that appeal review is perfected, the lower decision-making body loses its jurisdiction over challenged decision unless the statute specifically provides otherwise. In this case, the statutes do not authorize the county to take further action on its decision while that decision is being reviewed by LUBA or the Court of Appeals. Therefore, the county was without jurisdiction to adopt the challenged decision, and LUBA sustained the first challenge. So basically, if you move forward with this comp plan, you will be violating state law, and you would be subject to another LUBA appeal costing the county untold resources to do the record and everything else. The previous policy that the county has had is to, once you make your decision, which you've already made in the Sunny Valley case, is to wait to adopt that comp plan amendment until an appeal is satisfied, if there is such an appeal. That has been the policy. There's been no problems with it, and I don't see any reason for the county to change that policy at this time. It's founded in law. Okay. Can I submit this to the record?
Give it in.
I think Mr. Hicks will
make sure that our county attorney
exactly
has the copy of that.
All right. Thank you very much.